Okay, so hello everyone. Today we will talk about 3 years LLB sample paper of MHCET Law. Okay, and today we will see the legal reasoning and legal aptitude part. So let's start. First question is, what is the primary purpose of a writ of habeas corpus? And the options are to protect personal liberty, to enforce contracts, to analyze contempt of court, or to issue injunctions. Okay, so let's see the answer. Okay, so here are our answer. It is the option number one, which is to protect personal liberty. And its explanation is the writ of habeas corpus is issued to ensure that a person detained or imprisoned is brought before the court to determine whether their detention is lawful. It protects an individual's fundamental right to personal liberty under Article 21 of the Constitution of India. So what this question talks about is like, there are writs issued by the Supreme Court. So these are types of writs. So habeas corpus, this is a type of writ which is issued, issued, why it is issued or what it is about. Okay, so it is about our personal liberty, just to, protect our personal liberty. Okay. Second question. Which article of the Indian Constitution deals with the right to equality? And everybody knows that is Article 14. Okay, so here it is our explanation. Article 14 of the Indian Constitution ensure the right to equality by guaranteeing equality before the law and equal protection of laws within India. This forms the cornerstone of the Indian legal framework for non-discrimination. Okay, so we have right to equality, so nobody is, discriminated on the grounds of race, religion, caste, sex, everything. Okay. So this is about right to equality, which comes under Article 14. Okay. So let's see our next question. Our next question is, a contract without consideration is valid under which condition? So, if a contract is, you know, like valid in which conditions, so we are having these four options. Okay, so let's see. It is signed in the presence of a magistrate, it is in the writing and registered, it involves a minor, it is entered into by a portion. Okay, so let's see your answer. So let's see the explanation here of the third question. It is in writing and registered under Section 25 of the Indian Contract Act of 1872. A contract without consideration is valid if it is made in writing and registered under the law. Okay, so if it is, without consideration, a contract happen, but it will be valid if it is in writing and registered under the law. Okay, provided it made out the natural affection between the parties. Okay, so let's see the fourth one. Volunteering non-fit injuria means. Okay, and the options are damage caused by negligence, consent neglects, liability, no one shall be condemned unheard, ignorance of the law is no excuse. So let's see our answer. Our answer is B. Consent neglects liability. The Latin maxim, volunty non fit injuria, means if a person is willingly consent to a risk or harm, they cannot later claim damages of injuries caused by at the risk. For example, spectators at a sporting event assume the inherent risk involved. Okay, so our examples are like if a person is, uh, you know, uh, takes part in a sports event, so he or she, accepts the assumed, risk involved in that sport. Okay, so let's see the next. This is an example of this concept neglects liability. This maxim. Okay, and then we have the fifth one under the IPC. What is the punishment for committing theft under section 378? Okay. Imprisonment up to 2 years, imprisonment up to 3 years or fine or both, imprisonment up to 5 years or fine only. So our answer is imprisonment up to 3 years or fine or both. Okay. Under Section 378 of the Indian Penal Code (IPC), which was earlier, now it is Bharatiya Nyaya Sanhita and everything, theft is punishable with imprisonment up to 3 years, okay, a fine or a both. Okay? Theft is defined as dishonesty, taking movable property without the owner's consent. Okay, let's see the next. So now let's start with our sixth question. Which of the following is an essential element of a valid contract under the Indian Contract Act of 1872? So the options are free consent, coercion, incompetence of parties, or illegality of the object. So let's see the answer. Okay. So here our answer is first, that is the free consent. Why? For a contract to be valid under the Indian Contract Act of 1872, it must involve free consent of the parties. This means the agreement must be made without coercion, undue influence, fraud, misrepresentation, or mistake. That is under Section 14. Okay. So what does this mean? It means like they are forming a contract or an agreement, then the two parties which are involved, they must, respect each other, or the contract should happen without any form of oppression, or like suppression, or any threat or anything. Okay. So free consent should be there while forming a contract. Okay. So seventh question. Under the law of tort, strict liability was established in which case? Okay, so these are the cases. And we will see in which of these cases the strict liability of the law of torts was established. Okay, so these are the four cases. And the answer is, so let's see the answer. So answer is Silence versus Fletcher. So the principle of strict liability was established in Rylance versus Fletcher 1868 case, where the court held that when a person brings a dangerous thing into their property, is liable for any damages it causes, even if no negligence is involved. Okay, so what happens is if a person brings any harmful, metal rods or everything, so if it, it causes problem, or like to the neighbors, so it is the person or the owner's responsibility to handle those damages. Okay, so this is what happens here. So next question is, which of the following is a fundamental duty under Article 51A of the Indian Constitution? So these are the options: right to education, safeguard public property, freedom of speech, or right to equality. So the answer is safeguard public property. How? Article 51A of the Indian Constitution lists the fundamental duties of citizens, which include safeguarding the public property, promoting harmony, and respecting national symbols. So these are fundamental duties, as you all know. Okay, these duties are meant to promote responsible citizenship. Okay, so how we will become responsible citizens? These are the fundamental duties given to us. Okay, the maxim ignotia juris non exusit means. So these are the options. Ignorance of fact is excused. Ignorance of law is no excuse, or a person cannot benefit from ignorance, or knowledge of a law is presumed. So the answer will be D. Ignorance of law is no excuse. How? The Latin maxim ignotia juris non exequent signifies that not knowing the law does not absolve a person from legal responsibility. This means if a person don't know the law, or if a person does a thing, and he doesn't know a law exists on this particular thing, but still he will get punishment. Just because you don't know about the law doesn't mean you will not get the punishment. Okay, so this is what it is. This principle ensures that people cannot escape liability by exclaiming ignorance of the law. Like, you don't know the law, that's why you can't escape the uh, liability. It will be a liability, and you can't escape from that situation, right? So next question, which among the following is a type of preventive detention? Okay, so these are the options: habeas corpus, mandamus, preventive detention under Article 22, or quo warranto. So the answer is preventive detention under Article 22. Okay, how? Preventive detention, what does this mean? So it refers to the detention of a person to prevent them from committing an offense. So if a person, if there is a criminal or someone, they have past records, so our government or police can, what they can do is they can uh, uh, preventive detention can be, like made there so that the person does not commit any offense further. Okay. So Article 22 of the Indian Constitution provides for preventive detention laws, allowing authorities to detain individuals without trial for a specific period under certain conditions. Okay. So this is how it is. Now, the question number 11, what is the limitation period for filing a suit for breach of contract? So, if a contract is breached, you have, how many years, like the limitation period for filing a suit. Okay. So, options are 1 year, 3 years, 6 years, or 10 years. So, answer is 3 years. How? Under the Limitation Act of 1963, the limitation period for filing a suit for breach of contract is 3 years, starting from the date of causing of action. So, for example, if a breach of contract happened on 1st of June of 2024, then the person, can file the suit from the date till 3 years. Okay, that's the time limit they have. Okay, then question number 12. What does res ispa locure mean in legal terms? Okay, a fact speaks for themselves. Justice delayed is justice denied. No one shall be condemned unheard. Let the buyer be aware. So our answer is a fact speaks for itself. Example, it is a Latin maxim used in tort law. It applies when the very nature of an accident implies negligence without requiring direct evidence. Okay. So this is what happens. Like if I don't have a license of maybe a motorcycle, okay, and I ride the bike or the motorcycle on the highway, and if I cause an accident, then the fact speaks for itself that I don't have a license, I don't know how to drive, and then I met an accident, so it's obviously my fault. Okay, so that's a fact speaks for itself. Okay, that's res ispa locure. Okay. So under which section of the IPC is punishment for defamation prescribed? So this is the 13th question, and these are the sections: section 299, section 302, section 499, or section 503. So the answer is section 499. Explanation: Section 499 of the Indian Penal Code defines defamation, and Section 500 prescribes its punishment. Okay, so let's just go with it. And earlier it was IPC, that was the Indian Penal Code, and right now, which like this mm, this punishment, or we can say as a law, is there? That is Bharatiya Nyaya Sanhita (BNS). Okay. So our next question, which of the following writs ensure the performance of a public duties by a public authority? Okay, so performance of public duties by public authority, yes. So these are the four options: habeas corpus, mandamus, certiorari, or prohibition. So what is the answer? Mandamus. Explanation क्या है इसका? Mandamus is a writ issued by a court commanding a public official or authority to perform a mandatory duty. Okay, so in this, the like mandamus is a writ issued by Supreme Court or High Court. So if a public servant is not performing its duty, or like whatever the things are, so the court can like issue the, or command them to perform a mandatory duty. Okay, that's it. So let's see the next. In contract law, considerations, these are the options: a promise made without obligation, something in return, a valid offer, agreement by free will. So, what will be consideration mean? So, this means something in return. Okay, so you are considering something in return. So, like, say, for example, you are buying vegetables from a vendor. Okay, so you are, like, they are considering money in return. Okay, so that's what consideration is made, like, mean in a contract. Okay. Consideration refers to something of value exchange between parties, forming a key element of a valid contract. Okay. So, 16th question. The concept of vicarious liability applies to joint tortfeasors only, or principal agent relationship, or independent contractors only, or none of the above. So, like the concept of vicarious liability applies to which type of like concept? Okay, so the answer will be principal agent relationship. How? Vicarious liability arises when one party, the employer or the principal, is held liable for the wrongful act of another, that is the employer or the agent, performed in the course of employment or authority. Say, for example, like a person is there, A, okay, and a person B works in the house of A, or like is the employer of A, okay. B is the employer of A, and A does, oh sorry, if B does anything wrong in the like time period of being the employee of the A, then the A is also responsible. Okay, that is the principal agent relationship, which is what vicarious liability is all about. Okay, so like if your servant or your agent or your employee does something wrong, when he or she is in your like um the authority, like someone is working with you from the time 9 to 6, then the things which he or she performs when he's working with you, you are responsible. Okay, that is what vicarious liability is in simple terms. Okay, which among the following is a feature of the rule of law? Equality before the law, arbitrary decision making, execution, exclusion of judicial review, or concentration of power. So from the very like first instinct, we know that the rule of law is all about equality before the law. Okay, everybody is equal. This is what rule of law is. Okay, so the rule of law ensures that all individuals, regardless of their status, are subjected to the same legal standards and are treated equally before the law. No one is superior, no one is inferior. Everybody is equal. Okay. So 80th question. What is the primary objective of the Consumer Protection Act of 1986? Okay. So these are the four options: to protect consumer interest, to regulate trade practices, to establish monopoly rights, to promote foreign trade. So from the name itself, we can know the answer is A, to protect consumer interest. Okay. So the explanation is the Act aims to safeguard the rights of consumers by addressing unfair trade practices and grievances. Okay. A tort is a, this is our next question. So these are the four options: breach of contract, civil wrong, criminal offense, none of the above. What is a tort? A tort is a civil wrong. How? A tort is a civil wrong resulting in an injury or harm for which the injured party may seek legal remedies such as damages. Okay. So this is what a tort is. Okay. It is a civil wrong. That's it. 20th question. What is the primary remedy for a tort case? Damages, specific performance, injunction, or declaration? Damages. This is the answer. So the usual remedy in tort cases is monetary compensation or damages awarded to the injured party. Okay, so if a party is injured from, like any damages caused by them from a different person, so they are, like, damages or compensation is given to them. Okay, so the right to constitutional remedies is provided under which of these articles? Article 19, Article 21, Article 32, or 39? What is the question? Right to constitutional remedies. Constitutional remedies comes under Article 32 of the Indian Constitution. Okay. And Article 32 of the Indian Constitution provides the right to move to the Supreme Court for the enforcement of fundamental rights. So if your fundamental rights are being, like harmed or suppressed, or, like, someone violates it, you can move to the Supreme Court to, like have justice. Okay. Then the 22nd question: which among the following is an essential element of a crime? Mens rea, quid pro quo, or novation, or laches? Answer is mens rea. Explanation: mens rea, guilty mind, is an essential element of a crime along with actus reus, or guilty act. Supposedly, a act is done and like a place or a robbery is done. Okay, so a person, like does a crime, or maybe like robbery is, like done, then a person should have a guilty mind. Okay, so if a person is doing the robbery, he has something in his mind, like I will do this robbery or something like that. So he should have a guilty mind. Okay, and while doing the crime, okay, and that should be a guilty act as well. So like obviously robbery or theft is a guilty act. So that should happen. Okay, that's how we can, like essential have it is essential as to consider it as a crime. Okay. uh, Now the question 30, sorry, 23. The concept of natural justice includes right to appeal, fair hearing, procedural lapses, or specific performance. Fair hearing, where everybody has natural justice, so that everybody has the right to have a fair hearing. Okay. Natural justice principles include the right to have a fair hearing and the rules against bias. Okay. So this is what included in natural justice. Now, our today's last question, that is the question number 24. What does stare decisis signify? Binding precedent, justice denied, ignorance of law, or written contract? So the answer is binding precedent. How decisis is the principle that courts are bound to follow precedents established by higher courts. So if a higher court or a supreme court, like it does, like principle, they establish certain principles, then the district court or the subordinate courts are bound to follow that. Okay, so this is what stare diseases signify. Okay, so this is was our part first of our, like and this MHCET LLB program sample paper, and this was only legal aptitude and legal reasoning section. So now, like in other parts, we will discuss English and logical reasoning and GK and current